Hello and welcome back to NRI Legal World. Today we are going to discuss one of the most frequently asked questions, which is, can an NRI wife claim for husband's foreign property while filing for divorce in abroad? This question is very important for the couples who married in India and later settle in abroad countries. When divorce happens in foreign countries, then the property division rules, jurisdiction, recognition of divorce becomes confusing in India. Let's understand the entire issue step by step. Firstly, let's understand the basic legal background. When couples married under Indian law, certain rights and responsibilities arise automatically. The general rule in international family law is very simple. The court can decide the property which lies under their own territory. The simple meaning is that if the divorce case is filed in Canada, then Canadian court can only decide about the Canadian property, but not directly property which is situated in India. So, any claim to the property, it's totally depend on where the divorce case is filed and where the property is located. Now the question is, can NRI wife can claim for foreign property? So the short answer is yes. But it totally depends on the law of the country where the divorce is filed and where the property is located. If both husband and wife lives in foreign country, for example, let's take Canada, and the divorce is filed in Canada, so the division of the property will be governed by Canadian law, not the Indian law. Under most of the legal foreign system, including US, Canada, UK, Australia, property acquired during marriage is treated as joint matrimonial property, even if it is registered on one spouse's name. Therefore, NRI's wife can claim for equal share of the property assets which were acquired during the marriage in that country. The next question is, what about the property which is located in India? A very important point. Foreign courts do not have jurisdiction over immovable property which is located in India. Even if Canadian or British courts divides the property, its order regarding the Indian property is not automatically valid in India. This is because Indian property is governed by the law of the place from where it exists, called lex situs rule. Only Indian courts can legally transfer the property or restrain the property. So the foreign divorce court cannot change the ownership of the Indian property, though it can be considered in the calculation of the value while determining the overall financial settlement. Now the next question is, claiming husband's property in abroad. If both spouse, husband and wife lives in abroad and wife files for the divorce in that country, her rights to claim the husband's foreign property in abroad will be determined by that country's family law. In Canada, the concept is equalization of net family property. The court calculates total property gained by each spouse in the marriage and then divides the differences equally. Even if the property is under the name of the husband, wife is entitled to get half of the property what was accumulated during the marriage. In United States, law vary by state. Some follow community property principle 50-50 split, while others follow equitable distribution, meaning the court divides the asset but not necessarily equally in manner. In United Kingdom, courts apply fairness and equality. In the landmark case, White versus White, equality is the starting point of division. Wife can claim the property acquired during the marriage and spousal support based on her needs and the lifestyle during the marriage. Now we will understand Indian perspective on foreign property. If the divorce petition is filed in India, the wife can still seek relief, maintenance, alimony and residential rights under Indian law. But Indian courts cannot directly divide foreign property. Indian courts, however, can take in account the husband's foreign assets while deciding the maintenance and lump sum alimony. For example, if the husband owns a house in London, the Indian courts cannot directly order to sale or transfer of that property, but it can calculate maintenance while keeping in the mind the value of that property. The wife's claim in Indian law includes maintenance under Section 144 BNSS 2023, permanent alimony under Section 25 of Hindu Marriage Act, right to residence and protection under Domestic Violence Act 2005, claim to Stridhan and joint property under Section 27 of Hindu Marriage Act. Here are the steps for NRI's wife to claim for the foreign property. Step 1. Determine jurisdiction. Decide whether to file the divorce case in India or the foreign country. Jurisdiction decides which law. Jurisdiction decides which country's law will apply. Step 2. Financial disclosure. In countries like US, UK, Canada, both couple must file a complete financial statement listing bank account, real estate and investments. Concealing assets can lead to serious penalties. Step 3. Seek freezing or injunction orders. If there are risks that husband would sell or hide the property, the wife can seek the order from the court, often called Mareva injunction, to freeze those assets temporarily. Step 4. Apply for equalization or division. Based on local laws, she can claim for the half of the share of the property which was acquired during the marriage, even if it is registered under husband's name only. Step 5. Enforce judgment in India if it is necessary. If the foreign courts awards the financial sum, it is enforceable in India under Section 44A of the Civil Procedure Code. For non-reciprocal countries, a fresh suit will be filed using foreign judgments as evidence. One of the most frequent asked question is, what happens if husband hides the property? If husband hides any property and transfers into relatives' name, then this will be conducted a serious misconduct in countries like US, USA, Canada. They can reopen the settlement and impose heavy penalties, and even it can award to the higher compensation to wives. In India too, if husband hides assets, the court can consider while determining the maintenance and alimony amount. The wife can claim her stridhan and prove financial contribution to joint held property. Let's take one practical example. Suppose a couple, Aman and Ritu, who married in India and later they moved to Toronto. Aman buys a flat in Toronto and also buys a car during the marriage. After 10 years, both decided to separate. Ritu files divorce case in Canada. Under Canadian law, the court calculates net property of both. Since the assets were acquired during the marriage, Ritu will receive half of the assets. Ritu will receive half of the matrimonial wealth and support, and possibly the spousal support. If Aman also owns a flat in India, the Canadian court cannot directly divide that property, but the value of that property can be considered at the time of determining overall financial settlement. If Ritu wants direct claim over Indian assets, she can file a case in India for maintenance or injunction for the stop of sale. To conclude, an NRI wife can claim husband's foreign property, but the success of the claim depends on the country law, where the divorce is filed and where the property is located. Indian courts can consider the foreign property while calculating maintenance and alimony, but cannot directly divide or transfer the property which is located in abroad. If the foreign divorce is fair, genuine and follows due process, it will be generally recognized in India. However, if it is taken without the participation of wife or fraudly, it can be challenged in Indian courts. An NRI wife should always consult Indian and foreign lawyers, ensures full financial disclosures. That was the detailed explanation on whether NRI wife can claim husband's foreign property. If you found this video useful, then like, share and comment. Stay tuned for more legal updates on family and property law. Thank you so much for watching this video.